In the third part of the lecture series that dealing with constitution, democracy and judiciary, we will discuss regarding independence of judiciary, so how it establishes rule of law and separation of powers, then the constitutional mechanism. And regarding that, we found the security of tenure, their salaries and allowances and prohibition on practice after retirement and appointment process, and the functional autonomy provided to the judiciary as under Article 124, 125, 217 and 220, and those important leading cases relating to that and the very challenges faced, such as political interference, post retirement appointments of judges, then media trials, and judicial overload. Then we will discuss regarding efforts to strengthen the National Judicial Commission, financial autonomy to judiciary, then cooling off periods, and judicial education and training on ethics and professional conduct, then accountability and transparency, the very impeachment process, in-house procedure, code of conduct, then you see National Judicial Appointments Committee, then the Right to Information Act, then judicial standards. So the very suggestions regarding the reform judicial conduct commission, disclosure of judges' assets, appraisal of the matrix, and transparent appointments and transfer. Then we will discuss regarding judicial activism versus judicial restraint, and in particularly the public interest litigations and landmark judgments, merits and drawbacks of judicial activism, then with restraint cases and striking a balance in between judicial activism and judicial restraint, and in that connection we will discuss landmark judgments and their everlasting impacts, such as the important leading case Keshavananda Bharati versus State of Kerala in 1973, Menka Gandhi versus Union of India in 1978, Vishaka versus State of Rajasthan of 1997, Saravanu versus Union of India in 2017, Navjot Singh Johar versus Union of India in 2018, then Indian Young Lawyers Association versus State of Kerala in 2018. So, judicial independence is a foundational principle of the rule of law. It implies that judges should be free from external pressures, whether from the executive, legislature, or powerful interest groups, while discharging their duties. The Indian Constitution, judicial conventions, and institutional structures collectively support these principles. Constitutional provisions ensuring the very independence of judiciary that we found regarding security of tenures of judges, and judges can only be removed through impeachment for proven misbehavior or incapacity, as provided under Articles 124 in case of judges of Supreme Court and Article 217 regarding judges of High Courts. Then regarding salaries and allowances, which are determined under Article 125 of the Constitution, determined by law and not subject to arbitrary executive discrimination. or discretion, prohibition on practice at post-retirement practice in courts where the served is restricted to avoid conflict of interest as provided under Article 220 of the Constitution, and the very appointment process, though criticized for the very legality and the openness, the collegium system reduces executive interference, and those judicial pronouncements, in particular in S.P. Gupta versus Union of India in 1981, the Supreme Court declared that judicial independence is part of the basic structure of the Constitution. Later, in the second judge's case in 1993, the court reinforced the primacy of the judiciary in judicial appointments. Then the very functional autonomy that judges have control over court administration, listing of cases and judicial proceedings. The financial autonomy remains a challenge. Some states and the Supreme Court have made strides in digitization, e-filing and infrastructure upgrades. And the very threats to challenges to judicial independence that we found as political interference, which delays in appointments and transfers of judges into the Supreme Court and various high courts in India. And as regarding post-retirement appointment, which raises concern about the neutrality of Indian judiciary. Media trials impact judicial perception and undermine due process. Judicial overload, having huge number of cases pending throughout different high courts and even in subordinate courts, even in Supreme Court of India, it weakens timely justice delivery system. Strengthening the very independence, the recommendations to strengthen the Indian judiciary by establishing a National Judicial Commission for transparent appointments, enhancing financial autonomy through dedicated judicial budgets, setting cooling off periods for post-retirement government roles, then encouraging continuous judicial education and ethics training for judges. And now we'll go to judicial accountability and transparency. While independence is vital for the judiciary, it must be balanced with mechanisms of accountability to maintain public confidence. Judicial accountability refers to the very principles and practices that ensure judges perform their duties fairly, ethically, and in accordance with the constitutional and legal norms. So, the very existing mechanism of accountability as relates to very impeachment process, as already we have discussed about impeachment, judges can be removed through a constitutionally mandated process involving parliamentary approval. However, its use has been extremely rare. In a House procedure, the judiciary has adopted an internal mechanism for addressing complaints against judges. This process is largely confidential, raising concerns about its viability. The Code of Conduct, a set of guidelines developed by the Supreme Court, governs the ethical conduct of judges. However, it lacks statutory backing. And as regarding National Judicial Appointment Commission, we sought to bring transparency to judicial appointment was formed under the National Judicial Appointments Commission Act 2014, was struck down by the Supreme Court in 2015 for violating judicial independence. Despite its nullification, the debate over reforms continues with calls for a reimagined balance system. Further, Right to Information Act and the role of judiciary in a landmark ruling in Central Public Information Officer versus Subhash Chandra Agrawal in 2019, the Supreme Court held that the office of the Chief Justice of India comes under the ambit of the Right to Information Act. This decision was a milestone in promoting judicial transparency. Judicial Standards and Accountability Bill proposed to be laid down enforceable standards of conduct for judges and establish a mechanism for handling complaints. And the very reforms that suggested formation of a statutory judicial conduct commission, regular public disclosure of judges' assets, then performance appraisal merits excluding content of judgments, then transparent appointment and transfer of procedures to be followed. These reforms could enhance public faith while preserving core judicial independence. Now we'll go to another important aspect, that is judicial activism versus judicial restraint. The debate between judicial activism and restraint concerns the appropriate extent of judicial intervention in legislative and executive domains. Judicial activism refers to the proactive role of judges in filling legislative gaps, interpreting the Constitution broadly, and safeguarding public interest. The Supreme Court pioneered public interest litigation in important landmark judgments delivered by the Supreme Court, in particularly Hussain Khatun versus State of Bihar in 1979, dealing with right to speedy trial. And in another important landmark judgment, that is Olga Tellis versus Bombay Municipal Corporation in 1985, it established right to livelihood as also falling under Article 21, that is right to life and personal liberty. Then in another landmark judgment, that is Vishakha versus State of Rajasthan in 1997, the Supreme Court framed guidelines on sexual harassment. So judicial activism often addressed state inertia and championed the rights of vulnerable groups. So the very merits that we found upholds constitutional values, provides relief in areas of executive failure, promotes social justice and inclusive governance. In spite of all this, judicial activism is criticized on the grounds it overstepping separation of powers, lacks accountability, may reflect personal ideologies of those judges who deliver specific judgments with providing guidelines. So now we'll go to what exactly judicial restraint means. Judicial restraint advocates caution and deference to elected bodies respecting the constitutional mandate of parliament and state legislatures. It emphasizes the role of the judiciary as interpreter, not creator of or maker of laws. So the queue and the very important landmark judgments relating to this we could discuss. State of Rajasthan versus Union of India in 1997, which limited judicial scrutiny of presidential discretion. And in S.R. Mumbai versus Union of India in 1994, balanced approach to President's rule as provided under Article 356 of the Constitution of India regarding breakdown of the constitutional machinery in a state. Then striking balance a judicious mix of activism and restraint ensures that courts intervene only when necessary, while avoiding governance by judiciary. The concept of judicial statesmanship advocates timely, reasoned, and limited intervention to protect constitutional goals without usurping legislative or executive functions. So, in that connection, we would discuss certain landmark judgments and their very impacts. So, Indian judiciary, through its landmark judgments, has significantly influenced legal development, public policy, and social transformation. The judgments not only interpret the law but also reflect the evolving aspiration of Indian society. So, the first landmark judgment that left lasting impact is the Keshwananda Bharati versus State of Kerala in 1970. The historic verdict established the basic structure doctrine ruling that certain fundamental features of the Constitution like rule of law, separation of powers, and judicial review cannot be amended even by Parliament under Article 368 of the Constitution. It preserved the supremacy of the Constitution over transient political will, and in particular in the second landmark judgment that we would like to discuss here, Maneka Gandhi versus Union of India in 1978. This case expanded the interpretation of Article 21, which deals with the right to life and personal liberty. The court ruled that procedure established by law must be just, fair, and reasonable, laying the foundation for procedural due process and expanding the very scope of personal liberty in India. Then another important landmark judgment that left lasting impact is Vishaka versus State of Rajasthan in 1997, faced with legislative vacuum on workplace harassment. The Supreme Court issued binding guidelines to ensure women's safety and dignity. These were later codified into the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013. And another important landmark judgment delivered by the Supreme Court and having lasting impact is Navtej Singh Johar versus Union of India in 2018, where in a historic verdict the Supreme Court decriminalized consensual homosexual relationships, striking down parts of Section 377 of Indian Penal Code as unconstitutional. The judgment reaffirmed the right to equality, privacy, and dignity for the LGBTQ community. And the next important landmark judgment leaving lasting impact is Indian Young Lawyers Association versus State of Kerala in 2018. The court lifted the ban on the entry of women of menstruating as in this Sabrimala temple ruling that it violated articles such as Article 14 relate to right to equality, Article 15 regarding non-discrimination, and Article 25 relating to freedom of religion. Though controversial, the judgment marked a progressive stride towards gender justice, and the last important landmark judgment leaving lasting impact is Saravano versus Union of India in 2017. The very practice of instant triple talaq or talaq that was declared unconstitutional, reinforcing the rights of Muslim women and ensuring gender justice. Under constitutional principles which compel the Union government and the Union Parliament to enact Muslim women's rights and Protection of Rights and Marriage Act 2019. The judgments reflects the dynamic character of the judiciary of India and its commitment to constitutionalism, social reform, and the protection of marginalized voices in India. So, hereby we have completed the third part relating to constitution, democracy, and judiciary, and all those very judgments that we have discussed in brief. Already we have discussed in length in our lecture series relating to the playlist landmark judgments, and in connection to the very constitution. In theoretical aspect already we have discussed under two lecture series about the constitutions, and also in particularly the Constitution of India and in relating to democracy. Almost we have discussed in two parts what exactly democracy means and what are the different forms of democracy and the very functions of democracy. So in our next upcoming lecture, we'll discuss part 4 and part 4 of the series relating to constitution, democracy and judiciary. Will cover in detail those challenges faced by judiciary and those efforts and reforms suggested to strengthen the judiciary and judicial mechanism